All right, well, let's get going. I want to thank everyone for joining us this afternoon for our presentation titled Keeping the Golden Years Golden, where we're going to be talking about various estate planning matters. My name is Nate Skemp. I'll be one of the presenters today. And before I introduce the rest of our panel, just want to briefly go over some housekeeping matters. We're going to be lasting 60 minutes, roughly 45 minutes of the presenters talking, and we'll open it up to questions for approximately 10 to 15 minutes. Today's session is going to be recorded, so don't worry about taking a bunch of detailed notes. It'll go out to all the participants as well as be available on our Facebook page. Throughout the presentation, if you have any questions, please don't hesitate to put that into the chat on the bottom of your screen. I'll be able to monitor those. I just want to remind everyone we're keeping things fairly general today, so if you have specific questions, please don't hesitate to reach out to any of the panels after this presentation. Now to our presenters, Kelsey Flock. She is a Dementia Care Specialist with the Aging and Disability Resource Center here in La Crosse County. Kelsey is a community resource who provides education and support for caregivers of people with dementia and focuses on community activity for allowing people with dementia to still remain active. We also have Gina Zumach, the Advanced Care Planning Coordinator with the social work section at Mayo Health Clinic here in La Crosse. She's been a social worker in La Crosse for approximately 22 years and has a lot of experience in long-term care, hospital, clinic, transitional care, and emergency planning. We also have attorney Matt Cromheecke. He's been practicing law for 16 years and specializes in elder care and estate planning issues. Like I mentioned earlier, my name's Nate Skemp. I've been practicing for approximately 5 years, and one of my focuses is estate planning. So without further ado, Kelsey, please take it away.
All right, thank you. So today we're gonna review basic estate planning techniques and concerns. We're gonna cover why it's important to complete these items listed on the screen here. And then, as Nate mentioned, we're gonna have time for discussion and other considerations. But first, I just want you to think about your motivations for signing up for a webinar like this or viewing it later. You may have been referred to it. You maybe saw the registration and thought, I should probably understand what's coming ahead, or I'm helping my in-laws or my parents, a spouse, and potentially some of this could be useful. So regardless of your intentions for signing up, we're really glad that you're here today. And I hope that you carry through on the action pieces of learning this information, because really it's about how you live now. Live now meaning learn about options for end-of-life services and care, implementing those plans to ensure those wishes are honored, voicing those decisions to family, friends, healthcare providers, engaging in personal or community efforts to improve end-of-life care, but also reducing the stigma. Unfortunately, stigma has probably created a rather large barrier for people to future planning. Stigma of what it means and what it doesn't mean. So really today's webinar and the other future series topics are going to give you a better understanding of those things so that you can make your decisions and wishes known versus having those decisions made for you later. I think all of us on here can provide example after example of when things aren't planned out or made known. There can tend to be a cascade of unfortunate events and consequences that follow. And so after the series, you're going to receive some tools to carry out those intentions. And I really want to emphasize doing this planning early as in 30s, 40s, 50s. So making sure that you're talking to people in those categories and encouraging them to start planning. You can always come back and reevaluate, make changes along the way. And really any age is good to start. The importance is that you start and take action. We could go to slide 3. There we go, next one. So why is this important? An aging state, an aging nation, that is kind of where we're at. Life-threatening diseases have decreased, medical advances, successful treatments have really improved our life expectancy. So causes of death are changing and we're living longer, which poses new and emerging aging illnesses. And you'll see on the screen there that the US population is really experiencing the largest growth in our 65 plus category. And so the reality is our demographic landscape has changed. 10,000 people turn 65 every day and will continue to until 2030. The oldest members of our baby boom generation turned 72 in 2018. And so the next few slides that you're going to see are going to be the state, and you'll see the blue deepening, and that's just showing our population growing 60 and older. So as you can imagine, what this means for you and I is a considerable amount of things. A lot has changed since those baby boomers were young. And now as they enter into adulthood, there really are different and unique things affecting our families than were back then. So childcare used to dominate the first 20 years of the work-life movement, but now we're really having to focus on elder care as more people are caring for loved ones or more people are in need of placement because of things like families being geographically dispersed, this emphasis on deinstitutionalization, along with people wanting to stay home and age well at home. There really are not going to be enough skilled nursing or assisted living spaces having bed space available to accommodate this aging tsunami. We have more non-traditional families, potentially second and third marriages, no marriages at all, single parent family homes, and then as I mentioned, just being geographically dispersed. So now more than ever, it's really important to have your plans down and your wishes for your future. In addition to changes in the family unit, while it's not certainly new, it's certainly more prevalent, the illness of dementia. This can add a compound effect of poor planning and really muddy the waters. So right now in Wisconsin, there's over 123,000 people living in our state with dementia. That's enough to fill Lambeau Field and Miller Park. And those are people living in the community, not in assisted living centers or nursing homes. So it's important to know that dementia is not a normal part of aging, but age is the #1 risk factor. And you'll see some prevalence rates there on the screen. So when people live longer, we tend to experience dementia at greater rates. And unfortunately, due to stigma or denial, many of these people believe that they can continue to put off until later their plans. And when those wishes haven't been made known, and then we have a cognitive deficit come on board, it can really make things more difficult for them and for families. So the reality is, whether it's dementia or just general aging, it really comes down to caregiving. You're either already are caregiving for someone or you will be involved in a caregiving situation. So 85% of caregivers provide care for relatives, most commonly a parent or a parent-in-law. 1 in 6 of all employees are caregivers, 61% of those identifying work-related impacts or having to leave the workforce early. So by future planning, you're not only alleviating some stress for yourself, but also for your loved ones or people that will be expected to carry out your wishes. So do it for yourself, but also doing it for them. Get your wishes and decisions laid out. By future planning, you can avoid unnecessary financial burdens, emotional turmoil, and family stress. So now I'm going to send you back over to Nate and Matt, and they're going to dig deeper into estate planning, and later Gina's going to talk about that importance of the healthcare power of attorney.
And I'll go ahead and jump in right there. Thank you very much, Kelsey. So with this coming aging tsunami, estate planning becomes ever more important, not just for the individual that is aging, but also for their extended family. We find with those dementia effects, oftentimes that individual putting off that planning, it becomes very important for the family. That means loved ones, spouses, children, having those difficult and crucial conversations with that loved one to make sure that things are planned for as we go forward. As lawyers, we use this term, estate planning, and oftentimes I find that scares people away from what we're actually attempting to do here. But this is not rocket science. This is just basic, good standard planning that we use in order to make sure that the individual that elderly person, that their desires and wishes are taken into account, are properly voiced and properly dealt with before we run into something else happening that's going to take over, where we avoid that cascading of bad things or unintended consequences, basically. So estate planning, typically for a very basic estate, is going to involve 3 different documents, and that's a will or a trust. With a smaller estate and a more basic estate, it's going to be a will. Most people I've found are fairly familiar with that type of a document. It typically is also going to include, and honestly should include, 2 different powers of attorney, at least in the state of Wisconsin. The first one being a financial power of attorney, or a durable financial power of attorney is the way we will oftentimes describe it. It also has to include a healthcare power of attorney. And as we go through with this presentation, Nathan is going to be going over considerations with regard to your will, as well as a financial power of attorney. And then we're going to ask Gina with Mayo Clinic to go over the healthcare power of attorney. With the rest of my time, I'm going to describe what we're talking about, what actually happens if we don't do this planning, or what actually is going to happen that's going to take over. And primarily what I'm getting at, or what we're getting at, is what is that something that happens? And typically that something is going to be either someone that individual passes away, or they become incapacitated. Otherwise, we would call it they're going to become incompetent. So if you don't do the type of planning that we're talking about, oftentimes there's other procedures that are going to take the place of you doing that proper planning, that standard planning that we would look to do. So you'll find that when we actually go through the planning process and you do draft these wills, these powers of attorney, etc., you actually get to maintain the control that you're looking to have in your life and how things go through the rest of your older years, essentially. The other thing to keep in mind is that it tends to be, well, I often run into people that are very concerned about how expensive it is to hire an attorney to go through the estate planning process. But oftentimes I find that they're missing the bigger picture here, which is going through and having those conversations with your family as directed by a qualified attorney is actually less expensive than on the back end when you find out what ends up happening when you don't do the planning in the first place, or when you're rushing to do the planning when that something happens. Someone is becoming incapacitated, they can't take care of their affairs any longer, or they have actually passed away. You'll find that with these documents we're describing, you can oftentimes entirely avoid a guardianship. I usually tell people probably 9 out of 10 cases we're able to avoid the guardianship if we've properly planned with good, well-drafted powers of attorney on the front end, and then avoid that guardianship on the back end. And oftentimes with regard to probate and drafting of a will, we're going to be able to either plan for that probate, which makes it go much more efficiently and is much less costly and time consuming, or sometimes we can actually even avoid that probate on the back end. So with that, just the way I just described that, I just talked about 2 different things, and that is a guardianship and a probate. Those are the legal processes to deal with someone that's become incapacitated when we're dealing with a guardianship, or with probate when someone has actually passed. Those are the legal processes that we use. So I'm going to dig a little deeper into discussing guardianship as we go forward here. So guardianship is essentially the legal process that the state uses when an individual has become incapacitated. It's literally a legal process where a judge makes a determination as to whether that person no longer can manage their affairs, and then identifies who would be the person that would be handling their affairs going forward. That person is known as the actual guardian. The law deals with this area as a black and white issue, meaning it's on or it's off. This person either is competent / does have capacity, or they don't. And that's in the law, it's very simple and it's very black and white. In reality, and I know for a fact that our folks with ADRC and with Mayo are almost certainly going to agree with me, in that in reality, capacity is a much more of a gray issue. For extended periods of time, you'll see people as they age start to have difficulty with certain things, and we can provide some examples. For instance, mom or dad might start having difficulty, they might start making bad decisions. They might start having difficulty managing their checkbook or paying bills in a timely fashion, or even adding and doing that sort of thing. They might start physically starting to have issues with like falling down. They may start having difficulty remembering. People that are typically in those types of situations aren't necessarily unable and aren't necessarily incapacitated from a legal perspective, but they certainly, but it's certainly a time when we want to start helping them basically and giving them additional supports. Hence, it's extremely important to have powers of attorney in place in order to take that over, so that we're not just looking at a guardianship to deal with that sort of thing. Okay, and the process of guardianship, which is the backstop, meaning if we don't have properly drafted financial and healthcare powers of attorney, is relatively long, can be drawn out. It requires several different reviews by a medical professional, by the court, by multiple attorneys typically. And you'll see in this slide that we're looking at right now, kind of several of the things that are going to happen. First of all interested persons, those are going to be your spouse and your children, are going to be notified and brought in to have their opinion basically, and to be able to have their opinion in front of the court. There's going to be a legal, a guardian ad litem named on behalf of the individual that we're looking at, which obviously adds expense and time to get through the entire process. There will be a medical evaluation typically of that individual, or there will be of that individual. Again, time and expense. There'll also be a comprehensive evaluation by a social worker. This is all time consuming and expensive to engage in. And it also requires, it may have additional family input that's, again, expensive, time consuming, and lacks predictability as to what's going to end up happening. One thing I will say also is, for those of you that are aware, keep in mind that our second item, our second piece of this webinar is going to dive much deeper into this entire guardianship process for people to get a sense of how this all plays out. But for our purposes here today, I just want to make sure that you understand that it is far superior, much more preferred to properly draft financial powers of attorney as well as healthcare powers of attorney to attempt to avoid the guardian process itself. With that said, I'm going to actually ask that we flip to the next slide there. With that said, I'm going to go into probate. And with probate, typically, that's the legal process that is used in order to transfer assets on an individual's death when a different process hasn't been used. A standard, typical way of transferring assets is to probate a will that you would draft with an attorney. Probate isn't necessarily something to avoid all of the time. However, it is something that we typically want to avoid to the extent that we can, because it oftentimes is also fairly expensive, time consuming, and provides a forum for issues that we may not want to have aired in court and that sort of thing. The big thing to keep in mind with that is typically the something that is going to occur where someone is obviously when someone passes away. And I can tell you, just to provide an example of the kind of things that happens when you don't properly plan for this, is you end up with your loved ones, your spouse, your children, anyone else that's around you that cares about your circumstances, typically looking for a will, typically looking to find out where assets are, what kind of obligations there are, trying to determine who's in charge and who's supposed to take over. It's very confusing for families if we don't plan for what happens when we are no longer here. You'll have siblings looking at each other as to who should really take over. They won't really understand. They won't have a readily available attorney or other advisor that can kind of help them walk through the process itself and make it relatively quick, relatively easy. So it's very important that you walk through this ahead of time. Okay? I'd ask you to turn the page. The probate process itself typically takes, depending on the assets, it can be relatively quick, but it also can take a year or even longer sometimes. What does happen during that process is each interested person, which is basically your spouse, your children, anyone else that's closely related to you, if there are no spouse and children, are going to be notified and going to be able to, again, have their opinion and their position heard with regard to your estate. There's going to be notice published for creditors in the local newspaper. There's going to be an inventory published 6 months after it's filed. There's going to be potentially fiduciary tax returns that are done, and there's going to be accounting of your estate. So in general, we try to avoid the probate process to the extent that we can. But really what we're trying to do when we're dealing with wills is we're trying to manage that probate process and make sure that everything is taken care of the way that it should be. From example after example after example, I can explain to you what happens when you don't. And generally, if you don't plan to draft your will and to walk through and have these crucial conversations with friends and family about what is supposed to happen, the process will take longer. There will be additional confusion among the people that you're dealing with. It will cost more. So I would strongly encourage everyone out there to, A, if it's you, make sure that you're having this planning done. B, if it's your parent, your spouse, to have the conversation with them. Because truly what you're doing when you're doing this type of estate planning work is you're really giving them the gift not to have to question, not to have to go through these issues with others, and not to have to really, and to make this as efficient and easy as possible after they pass. It is very common for people to be very emotional when someone passes away. You want to make it as easy as possible on your loved ones when you do, so that everything goes the way that you intended it to be, in a relatively efficient manner. And with that, I think what I'm going to do is turn it over to Nate to give you some additional information about considerations when you're drafting a will and or a durable financial power of attorney.
Thank you, Matt. To just kind of piggyback off Matt, the three main documents, as he said, we would discuss in a typical estate planning consult with our clients would be a will, financial power of attorney, and a healthcare power of attorney. But I also want to kind of piggyback off what Kelsey said is it's really no too early of a point in life to start talking about these documents and getting them in place because they can be changed. I also want to, remind everyone that you don't need this large estate to have this in place. I think Matt mentioned this. This is beneficial really for all adults. And I want people to also leave here today thinking about major life moments that would happen, because again, those are another indicator that maybe I should be talking about this. Did I get married? Did I have a child? Just know when those life events change that maybe I should be talking about putting these in place. One of the other things that I'd always talk to clients about before actually getting these documents in place are called POD and TOD. So this is payable on death and transfer on death. Matt mentioned about it a little bit. If your situation appears that we can put these things in place to avoid a probate, we will certainly discuss this, and these will take care of various financial accounts and potentially even real estate. But these are always something that we will discuss if this situation fits you. As to the will, the biggest thing I've seen with wills becoming invalid or challenged are simply the formalities. A benefit you have of coming to an attorney is that we make sure these formalities are absolutely in place in the documents. So at the very least, they're not going to be challenged for simply forgetting a basic step. The main ones are that the testator, meaning the person creating the will, is at least 18 years old and has capacity. The second one is that this will's in writing, that there's no recorded audio of someone saying where their stuff should be, that it's actually in writing. The third one is that the person signing the will, the testator, is signing in front of 2 witnesses, and these witnesses are disinterested, meaning these are not people that are going to inherit under your will. They're just completely disinterested. They're there just to verify who you are and witness your signature. Another formality that we offer is that this whole process that I just discussed is also notarized. And the benefit for this is that it really strengthens it and makes it even harder to challenge the will, meaning whoever's going to challenge it needs to overcome the presumption that this will is valid given the notary. The other main concerns, and again, Matt touched on this, is simply why would I do a will? And again, this is because people should have the ability and generally want the ability to control where their stuff's going and who's involved in making that process happen. Without a will, the courts are going to get involved, Wisconsin statutes are going to get involved, and you're going to lose control over how this stuff plays out. And generally, people do not want that. The biggest role in a will is who should be my personal representative, meaning who is this person that's going to look at my will and administer the distributions, pay the debts, who's going to follow what I said should happen. Generally, this should be someone you're really close with. The easy ones are spouse, children. If those people aren't in your life, siblings, other relatives, close family friends. You should also take into consideration when you're looking at these people, who's financially savvy, who do I trust, who's local. Those are all important attributes to this role because it is a role that requires some work, and it's important to put a lot of thought into who's going to be that role. We also suggest having a second backup and even possibly a third given the age and situation of the people you nominate. The other main concern is distribution. That's another crucial aspect that we want to discuss with our clients because, again, without that, the statute's going to tell you where things are going. When we discuss distribution, it'll be important to note, are you married? Because Wisconsin has certain spousal shares. Do you have non-marital children? Is this your second marriage, third marriage? These are all really key points we have to discuss because we have to be very careful about how we describe who's getting distributions within your will. Another key component is children and grandchildren. Generally, if someone turns 18, they're going to inherit. However, I think a lot of people have found, especially over the last 10 years, is that people aren't ready to inherit at 18, 20, even 25. So if you do have those concerns, we will talk about how to set up that will so people aren't getting things right away, where that money's going, who controls it, what happens to it until they reach an age you're comfortable with. And the other main concern people have all the time is, I see hesitation because they don't know if this is 100% how it should happen. They don't know if this person's going to be around in 5 years. And I just want those people to know that these wills can change. As long as you still have your capacity, we can make changes. Anything within that will can be changed. I briefly touched on this, a pay on death. Again, this is just, this is an issue we discuss when we meet to see if there's a way to set up your estate so that things occur right on your death without having to go through the probate process. As Matt mentioned, the other crucial estate planning document we discuss is called a financial power of attorney. Same thing as with the wills. Who is going to be this person? Generally, it's safe to say that the financial power of attorney and the personal representative usually are the same person. It's the same questions you're asking yourself. Who's responsible? Who do I trust? Who's local? They're not always the same, and we'll talk about them differently, but generally those are the same. We also like to keep our financial power of attorneys very broad. And the reason being, as Matt discussed, you're not going to want to have to open up a guardianship to get a specific power. That's going to be expensive and it's avoidable. So we have our power of attorneys very broad, allowing that agent to do a lot of things for the person making the power of attorney. Power of attorneys are also usually durable, meaning that after the person making the financial power of attorney becomes incapacitated, that the financial power of attorney is going to remain in effect. So given that, we always like to talk to our clients about when this is going to happen. When is the financial power of attorney in effect? Generally, it's in effect when people sign it. However, we will discuss if you think trigger language is necessary. And when I mean trigger language, do you want the financial power of attorney to not be in effect without a doctor saying the person is lacking capacity? Similar to will, people get nervous about doing this, but I always remind people, as long as you have that capacity, you're going to be able to change it. And now to talk about that third document we discussed, I'll pass it over to Gina.
Thank you. Yes, here in the healthcare institutions, you might hear us pushing often and asking every time you come in for your physical if you have your advance directive done. So specifically your power of attorney for healthcare. We're trying, as everyone had said, trying to prepare now for when something might happen. So action today can prevent a crisis tomorrow. So we are in the same boat with that as far as your healthcare goes. We see many examples of patients who come in emergently, and from a medical institution, we treat patients. We treat to stabilize and make sure that, you know, the emergent need is taken care of. But what we run into then is what happens afterwards. What happens when you are stabilized and you're sitting in ICU or you're sitting on a hospital floor and no one is there to make your decisions for you. You haven't elected people to be your agents, to act on your behalf, to share what your wishes are and what you want to have happen with your healthcare. If that's not in writing, if we don't have that, then we do the guardianship, which the others have spoken of, which we'll go into a little bit more. So here in Wisconsin, we are a bit more complicated than other states in the nation. So we have some very specific requirements. We are not a next of kin state, which means that if something were to happen and you came in an emergent situation and decisions needed to be made, we can't automatically defer to our loved ones. It doesn't automatically go to your husband, your wife, your children. And that starts when you're 18 and over. So for example, when my oldest son turned 18, I did a power of attorney for healthcare with him because even as his mother, I wouldn't be able to make decisions on his behalf. So we recommend it 18 and older, just get those agents down and in writing and start talking to them about what you want. You know, think about who that person would be for you. We know that family dynamics are not always easy and they're complicated. Family dynamics are complicated. So you want to think of who can best represent you and your wishes. And if that's a best friend, then that's a best friend. If it's a cousin, it's a cousin. You have to do what's right for you. And then, you know, also that person's ability to really advocate on your behalf. Some things might not be what they would agree for their own self, but if they are able to communicate your wishes in a loving way and, you know, thoughtful way to the healthcare providers, that's really what you want. Let's see here, advanced directives. It can be kind of a umbrella term really for a lot of different things. We've got, you know, power of attorney for healthcare. We have, you know, physicians and orders for life-sustaining treatments. We've got all sorts of things, but basically what we want you to have is a power of attorney for healthcare. In Wisconsin, we require 3 very specific things in the power of attorney for healthcare. And in our next slide, we'll show you the top 3. So the authority to admit to a nursing home or community-based residential facility for the purpose of long-term care, artificial nutrition and hydration, and pregnancy. What they're saying is that you're giving that agent the authority to advocate on your behalf in those situations. If those things are not completed in a power of attorney for healthcare document, then that would defer to a guardianship or a court order. So people oftentimes will complete their power of attorney for healthcare, but then they'll say no to the authority to admit to a nursing home. Unfortunately, that doesn't mean that you're not going to go to a nursing home. If for some reason you have a severe medical complication, you have a major stroke, you are unable to care for yourself, your family can't care for you, you have to use a lift to get in and out of beds, and you're just essentially total care. And families can't always maintain that in the home. That is a lot to ask. At that time, they need help. They need the placement. They need the options of having 24 hours a day, trained caregivers to provide that level of assistance. So when families come into the emergency room and they say, we can't do this anymore, and you've checked no, that doesn't mean you're not going to go. It just means it's going to go to court. So those are the three very specific things. Other things we will talk about in your document will be regarding CPR, life-prolonging treatments, organ and tissue donation, autopsy, pain management, special wishes. This document is yours. We put what you want, and that could be, we talk about everything, like even nearing your death and the type of, sacraments or religious, preferences you might have. We want to honor everything that you would want as your journey on earth ends. We want to make sure that you are honored. Let's see. So power of attorney for healthcare documents. Both Gunderson and Mayo locally have these documents. We have trained facilitators who are here to help you go through them. You don't have to do this by yourself. It can be very overwhelming. We have people coming in saying, I have a stack of these that I keep getting every time I go to the doctor, but I just don't know what to do. I don't know where to start. Well, we're here to help you. We're trained to do this, and we enjoy it. We want to make sure that you get everything you want in this document. And just because it's what you want right now doesn't mean that's what you're going to want in 2 years. That's okay. We'll change it. We'll make it your document as you continue through your life. We will do the documents for you. We will give your agents copies. We will scan copies to your electronic medical charts. We'll send them to the VA. We'll send them to UW-Madison. We'll send them wherever you go and get your health care, whatever makes it easiest. This is just a really good way to say, if it's going to be done, let's do it. Let's not put it in the hands of fate. Let's not put it in the hands of someone who doesn't know me. I know me best. Take a breath and just go ahead and get it done. And we're here to make that easier for you. I think the last page, again, is just how you can contact us. Go to Gunderson, go to Mayo. We will make sure that we get this document done the easiest way possible for you and answer all your questions if we're able to. Now I'll hand it back off to you guys.
Thank you, Gina. Just to recap before we open this up to questions, just some of the main key takeaways for today is that, and this sounds silly, but if you don't make the plan, you're going to lose that opportunity to. So it's important to really start those discussions soon, get things in place. Again, like we discussed, if they're not the right thing, they can be changed, but it's important to start that conversation right away. To kind of recap the presentation in general, the key documents to kind of be really thinking about are the healthcare power of attorney that Gina discussed, financial power of attorney, and the wills that I discussed, and just to make sure we avoid some of the issues that Matt went over. Now that we're complete, I'll open up the chat to some questions. I'll give people some time to type one in. I got one a little bit earlier that I'll open up to maybe Kelsey and Matt can both weigh in on this. This is a lot of information. What should we be doing first? What should be step one?
I'll jump in there. I mean, typically, I suppose it depends on where you are in your, I guess, life cycle. I mean, I'm an attorney, so I will say that typically I would say the first thing to do is contact your attorney. That might not always be the case, but I think that an attorney, a good attorney that knows these processes is probably a pretty good resource. If your estate is relatively large, and what I mean by that is, you know, what kind of assets you have, or if you have businesses or particularly difficult assets that you're dealing with, you're definitely going to want to get an attorney involved. But I have a strong suspicion that Kelsey may say, you know, you can probably talk to some of the social workers at ADRC or something like that as well. And I think that might be the case as well, but I have a strong suspicion we're going to kind of refer back and forth to a large degree depending on, you know, size of the estate, complications with family, those sorts of issues. And I know that that's a lot of words, but typically it's going to depend on where you are from a life perspective. I can tell you, once I know more facts about your situation, I can kind of frame up what the main concerns are and what to do next. And that's really where that advisor becomes valuable, that quality advisor becomes valuable. And just saying, what is this next step as to how to deal with this?
And I'll just jump in. If you call the Aging and Disability Resource Center in your county, we usually say we're your first stop shop for anything long-term care, aging questions. If you call us, we'll be honest and say you need to contact an attorney for that. In the meantime, have you considered these things? So we can help you kind of fill in the pieces outside of that, but we don't deal with obviously legal things, and we'll let you know where you need to go to get those done. So if you come to us with the question, any question, big or small, we'll say, yeah, this is where you would go to it. We connect you to the resources in your community.
All right, great. Another one, this may be for Matt first, and Gina, you can weigh in on your document. Where should these wills go once they're signed, and should they be shared with the personal rep? Same with the financial power of attorney, and then Gina, same with your documents. Who should have these and who should know about them?
That's an excellent question. I'm glad that was asked. So I've found that practice is a little different throughout the state with regard to your wills. At least as far as where they go from there. Typically, most attorneys I found are no longer going to actually hold on to the original will. And the original will is extremely important because that is the one that actually is produced to the court, to the probate court, when that individual passes away. In some areas of the state, I have seen that it's much more common to actually file that will right away after it's created, because then the court is going to keep it going forward. But most attorneys that I see in our area are typically going to turn them over to the client themselves, and then it's their responsibility to keep that original document. That's going to be the same with regard to the financial powers of attorney as well as the healthcare power of attorney. The bigger question, however, as to who should get them, who should have at least copies and have an understanding, I tend to be one that likes the family model of dealing with all of this stuff. I'd much rather have, you know, your spouse know what's going on, your children know what's going on, especially the children that you want to have involved in this process, knowing what's going on and actually having copies of the documents. I tend to even like, but obviously this depends client to client as to their level of comfort with this, but I tend to like to have spouses, children have questions answered even on the front end to make sure they understand what's going to happen when you become incapacitated or when you pass away. It just makes the whole thing go much more smoothly when those things actually happen in your life. And with that, I'm going to turn it over to Gina with her comments.
Yeah, I would agree completely with that. You know, we say, like, if you're choosing your agents, we absolutely want you to, you know, for those agents to have a copy of the document, but then also so that it sparks conversation. We all have people in our lives who are dealing with complex medical situations, people who have passed away. And at those times, that really is, it can ignite conversation. Oh, I really don't ever have me be on dialysis, but for some people, they're okay with that. But it's bringing it in the forefront. It's having those conversations. And the document is just the beginning. It gives you a tool to work from to keep those conversations going. So absolutely, the agents having them, where you get your health care is important. We do communicate as institutions. If someone is in a different facility, we do our best to get those directives to that institution as quickly as possible. But then also, we keep them on file here too electronically. So, and we just change as they change.
If you don't mind, I'm gonna jump in here as well. Typically, I do an estate plan. It would be very common for the client that I'm working with to already have or to decide to work with Mayo or Gunderson to have their healthcare power of attorney put together. And that's absolutely fine by me. The only thing I typically will ask is I would like a copy for my file. And I make sure that if they've done it with them to see if they, to make sure that they get a copy back to me so that I've got it in my file as well.
All right, Matt, maybe I'll just piggyback off one of the things you said. You like to talk to the families. Do you suggest having the families meet with you right away, everybody at once, or?
It would be uncommon for me to meet with everyone right away. And that's because there's attorney-client privilege that we're dealing with. So we always have to deal with that issue. So it would not be uncommon for me to meet with spouses right away. But then we're going to have a discussion about the potential for conflict even between the spouses. But I will say that oftentimes when you get into a more complicated estate plan or issues related to property or businesses and things of this nature, you might decide at some point to open it up to discuss with the rest of the family. But that would obviously be the client's decision to do something like that. Because of the confidentiality that attorneys and clients deal with, and the attorney-client privilege that we deal with.
Matt, I got a good question that I think you can answer.
Yeah.
What about trusts? People have heard about trusts when they talk about estate planning. I know that wasn't part of our presentation, but any comments generally on trusts?
Definitely. We at our office do a lot of different trusts. The most common that we're going to be doing are what are known as revocable trusts, or with spouses, it's going to be a joint revocable trust. Typically, that's going to be with an estate that's a little bit larger, and so that wasn't really the focus of what we're talking about here necessarily, and that's why you're not seeing much about it. But it's definitely something that we deal with regularly. One of the big advantages with that type of trust, that type of revocable trust, is that it's going to avoid probate. So if we're really worried about probate, it's going to avoid probate as long as it's properly put together and properly funded. It also provides confidentiality, because you're not necessarily creating a forum through the court system when that person dies and probating that will. It's outside of that entire system. So for instance, if it's a husband and wife with, say, 3 children or something like that, and maybe only one of them that we really want to know what's going on, we may do the revocable trust because we want to avoid the probate, avoid the fees and expense associated with the probate itself, so that then we pass away, that one child that we want to really be in charge is in charge, and we don't have to ask for court review or oversight or the expense associated therewith. But from a larger perspective, that type of trust is a very common planning tool, especially for states that tend to be a little bit larger. And again, it's the attorney that you really work with that kind of gives you what we're looking at for those break points. Like, is my estate the type that should be dealt with through wills? And paid on death beneficiaries or something like that? or is my estate more one that should be dealt with through a revocable trust? The other thing is there's all sorts of different types of irrevocable trusts and other types and styles that honestly is well past the scope of what we're going to be doing here today. So what I would do is, if you're really concerned about trusts or that kind of planning, you probably want to get to a competent attorney that can handle it.
Okay, Matt, and to piggyback off all this, we got, I mean, it's a tough question to answer, but is there a ballpark figure you start to really dive into the trust conversation with clients, or is it totally situational dependent?
I'm sorry, Nate, can you repeat, please?
Yeah, is there a ballpark figure when we're talking value of an estate where you start to bring up the trust conversation?
Yeah, I mean, La Crosse area, it depends on two things, well, several things, I should say. The size of the estate is definitely probably paramount. I would say when you're in the $1 million total estate figure, you're probably at least should be having that discussion with an attorney. But the other big factor is going to be the type of assets that you're dealing with. And I'll give you an example. If you have $1 million in total assets, but let's say 200,000 is in the value of your home and the other 800,000 is in a 401k or an IRA or something like that, you may be looking at just doing wills and not doing the revocable trust. Whereas if that extra 800,000 is in real estate, or it's in a small business or interest in small business or something like that, then we might be looking at the revocable trust type of planning that I'm describing. The other thing to consider is always the family dynamics. I mean, I will have people that have significantly smaller estates than what I'm even describing, and they're choosing to do these types of trusts because, say, for instance, they have one of those 3 children is not the best person in the world, and they really don't trust them in dealing with any of this stuff. The trust provides a lot more ability to avoid that person getting a foothold into what's going on, if that makes sense.
Yeah, that helped. And thank you for those who submitted questions today. So I think we can, if there's no more, yeah, we'll switch to the upcoming webinars. Friday, October 16th, same time, noon to 1. Matt did a nice overview of guardianship, but it's truly a fairly complex issue. So if that struck a chord with them, I'd encourage everyone to tune into the guardianship ones. Then Friday, October 3rd, we will do benefits planning. Matt will be involved in that one again, where we'll be talking about a lot of Medicaid issues, spend down issues. So hope to see everybody join at those. You can register at moensheehanmeyer.com/webinars. And finally, here is the contact information for the panel today. Again, feel free to reach out to anyone on this panel for more specific questions. We'd all be happy to talk with you. And again, thank you all very much for taking time out of your day to join us.